Argued this morning, and counsel for the first case are present. Before we begin, I wanted to let you both know that Judge Robert Winkler is also a member of this panel. He is not able to be here this morning, but he will fully participate in our deliberations in the decision-making process and will have available to him the oral arguments this morning. So I wanted to let you know that he is a part of our panel and will fully be participating. The first case to be argued this morning, and is it Allard or Kellard? I want to make sure I'm pronouncing it correctly.
Your Honor, I believe it's Kellard.
Thank you. The first case is...
Your Honor, I don't see the opposing counsel for Mr. Kellard in this. Mr. Haynes is also representing the city on a different matter that's before the court this morning.
You are correct. We are missing Mr. Phillips, or there's Mr. Hackett. Mr. Hackett, are you here today on behalf of Mr. Kellard? And you're on mute.
Here I am. Yes, I represent Mr. Kellard.
Thank you very much. All right. Thank you, Ms. Warner, for straightening that out. Because this involves an appeal and a cross appeal, I am going to allow each side 15 minutes total, but both sides may reserve any part of their time for a rebuttal argument. And are you both ready to proceed this morning? Ms. Warner, on behalf of the city, are you ready to proceed?
Yes, Your Honor.
And Mr. Hackett, are you ready to proceed?
Yes.
Ms. Warner, would you like to reserve any time this morning?
Yes, Your Honor. I'd like to reserve 3 minutes for rebuttal.
All right. And whenever you're ready, you may begin your argument.
Good morning, and may it please the court. Emily Smart Warner on behalf of the city of Cincinnati. So this case is about a policy that the city of Cincinnati wasn't enforcing, and that was changed to conform with state law in its entirety before the trial court entered a single order. So because this lawsuit was moot, and the lawsuit was not the but-for causation for the change in the city's policy, plaintiff Tim Kellard was not the prevailing party, and the taxpayers of the city of Cincinnati should not have to pay nearly $50,000 in attorney's fees because of this lawsuit.
Ms. Warner, the lawsuit was not moot at the time it was filed. Would you agree with that?
No, or yes, Your Honor. The policies were fully communicated after the lawsuit was filed, but before the trial court entered any judgments.
Okay.
So the city respectfully requests that this court reverse the trial court's judgment. Now, first, I'd like to talk about the justiciability argument. For a declaratory judgment, a controversy exists when there is a genuine dispute between the parties that has adverse legal interest and sufficient immediacy and reality. Here, at the point that the city changed its policies, there was no longer an actual dispute between the parties. The policies hadn't been enforced against Mr. Kellard. At that point, they fully conformed with state law. So there was no dispute at hand. The trial court also entered injunctive relief, a permanent injunction against the city. But that permanent injunction, again, there was no controversy at the point that the trial court entered the TRO or the permanent injunction because the city's policies had already changed. There was nothing for the court to enjoin. And in fact, tacitly recognizing this, the trial court and the arguments before the trial court were, oh, well, the city could change its policy to then violate state law at some point in the future. So there needs to be an injunction. But appellate courts that have been presented with this argument have flatly rejected that argument. That is not evidence of sufficient harm for a trial court to be able to enter a permanent injunction. So the cases that are all on all fours for this are the Oberlin case out of the 9th District and the Smollett case out of the 10th District.
Let's talk about Oberlin for a minute on the prevailing parties issue, because it really is a splintered decision on that issue, but would suggest, at least if you go with the lead opinion, that there is something to the appellee's argument here for entitlement to fees. So what's your response to that?
Yes, Your Honor. So what the Oberlin court does say, and what it reversed the grant of summary judgment, was whether the lawsuit was the but-for cause of the change. And the facts in the Oberlin case are different than the facts in the case presented to the court today. So,
well, but I mean, obviously the city was discussing this at some level, but they weren't taking action until the lawsuit was filed. So, I mean, isn't that enough for there to be some causation from the filing of the lawsuit?
respectfully, Your Honor, no. So the record before the court demonstrates that the city was literally moments away from signing these policies. And we have the documents that demonstrate that. So appellees say that there's no proof, but the record says otherwise. More specifically, Exhibit C, City's Exhibit C, that's part of the record, shows that the edits were made to the policy and the direction to change this policy occurred on March 19th, 2019. Exhibit D and D1 show the changes to the HR policy and procedure because there were two policies at issue, an administrative regulation and an HR policy. But then if you look at the documents themselves, so the administrative regulation, which is Exhibit J, it has a date of August 13th on it, which is 2 days before this lawsuit was filed. The city was entirely unaware of the existence of this lawsuit, and yet that AR, which conformed with state law, was dated on August 13th. Correspondingly, the HR policy and procedure was already prepared and dated on August 15th, which later that afternoon was the first time that the city was aware this lawsuit was filed. So while those changes were not fully communicated to the city employees until the following Monday, the record demonstrates that these documents literally just needed a signature on them, and they were dated before the lawsuit was filed. So that is why this case
The trial court didn't make any findings consistent with what you just said. So I understand you're saying that there is evidence to support the city's position, but how are we supposed to deal with the fact that there's no findings of fact consistent with that?
The trial court did admit, and the parties stipulated to each of those exhibits. So that is in the transcripts of the proceedings from the September 11th hearing. And so because those are part of the factual record, this court can find that the trial court abused its discretion in coming to the conclusion that the lawsuit here was the but-for cause of the change in the policy. And so that is why the plaintiff was not the prevailing party under the statute. Because of course, plaintiffs are not entitled to attorney's fees, the fee shifting, unless they meet the actual requirements of the statute. And that was the city's argument. The city's argument to the trial court was consistent to say, here are these facts. What they are confusing is essentially a correlation and causation issue. That if you had picked up the phone and let us know that you were concerned about this anonymously or not, we would have said it's literally on the city manager's desk about ready to be signed.
But there's no requirement that that be done, is there?
No, of course not, Your Honor. But it is frustrating in cases like this when completely independently of a lawsuit, the city had the policies on the table. And because the signature didn't happen within 48 hours, then the city's taxpayers have to pay $50,000 in attorney's fees.
Well, right, but I think that's also, I mean, the statute had been on the books for what, close to 2 years? And I mean, the city, as you acknowledge, was working on this back in February and March. And so, I mean, nothing prevented the city from just finishing the work and implementing the changes to the policy prior to the filing of the lawsuit, then we wouldn't be here.
Certainly, Your Honor. Now, the city was not enforcing the policies in a way that would have violated the statute, and that's similar to the Smollett case.
What is the evidence that the city wasn't enforcing the policies?
Your Honor, in review of the record, I think that was presented to the trial court as argument, and so I do need to concede that that fact may not have been stipulated to. However, there was no evidence presented that Mr. Kellard or any other city employee was subject to any discipline or threat of discipline. But I want to highlight in the Smollett case out of the 10th district, Columbus had said, we're just not enforcing these ordinances that are, violate the state statute. And that was sufficient for the 10th district to say this issue is moot. So because there's no evidence either way on the enforcement, and that is before the record today, and the policies were changed, the dates on the documents were before this lawsuit was filed, even if not every I was dotted and every T was crossed, and that is certainly the city's responsibility, it is not sufficient to find that the lawsuit was the cause of this change. And that's why the trial court abused its discretion in finding that Mr. Kellard was the prevailing party entitled to attorney's fees here.
Let me ask you one question about that. If we find that he was the prevailing party, is there any law that would say at some point in time it became clear that the city had enacted the policy? Is there any way that the attorney fees, is it an all or nothing, or can the attorney fees be parsed out as to a point in time? In other words, prior to the entering of the injunction?
Your Honor, the way that the statute is written is not clear on that issue. However, the statute does provide that a plaintiff is only entitled to reasonable attorney fees. So I think that's certainly something that a court can consider about what's reasonable and what's not reasonable. So there is that issue. Now, I believe that Mr. Kellard's counsel will raise that point and say that and the transcript makes this clear, that there was a point where the parties could have resolved the case. However, we need clarity on this issue about who is the prevailing party and what is the proof for that prevailing party issue. So that's why it did not resolve earlier, and we're before this court today.
Thank you, and you are at your time if you want to reserve 3 minutes.
Thank you, Your Honor. For those reasons, the city respectfully requests that you reverse the trial court.
Mr. Hackett, would you like to reserve any time this morning?
Yes, 3 minutes, please.
All right, and whenever you're ready.
This case is about forcing employers to uphold the law. The city of Cincinnati was violating 2 laws for over 2 years when Timothy Kellard filed his lawsuit on August 15th, 2019. The next day, the city amended their policies and began arguing. The first argument they make is that Kellard's lawsuit didn't actually cause the city to effectively amend its policies the next day. The argument is that it was either a coincidence, as raised in the brief, or that it was inevitable and that this is all fortuitous on behalf of Kellard somehow. The second argument is that Timothy Kellard's entire case must be dismissed once the city amended their policies.
So let's talk about that for a second. Once the city has changed its policy that was out of step with state law to conform to state law, how is there a justiciable controversy at that point?
The issue is compensatory damages, Your Honor.
Okay, well, but I want to stick on not damages, not attorney's fees, but specifically, you're seeking injunctive relief.
Yes.
And how is there a legitimate dispute or controversy once they change the policy?
Your Honor, we do not believe the city is entitled to an assumption that they were not intentionally and knowingly violating the statute for over 2 years. This statute came into effect on March 21st, 2017. 1 week later, two high-ranking city officials emailed each other saying, no, we're in violation.
So no, I understand. I understand your view of the city's action. That's not my question. My question is, at this moment in time, what I understand the trial court is saying was there is some possibility that the city might reenact this policy. So, I mean, is that your theory? I want to make sure I understand what your theory is for justiciability here.
Yes, our theory is that we do not believe the city is entitled to the assumption that they will not return to violating the rule if this appeal succeeds and they obtain dismissal of Timothy Kellard's case. I would like to distinguish, as proof, the case at bar from the Smolak decision. In Smolak, the city of Columbus entered an affidavit onto the record saying, we're not enforcing this ordinance. It is effectively off the books. The city has not put forth any testimony whatsoever that it will not go back to returning to violating this statute. This is how it's distinguishable from Smolak. We had the city manager and two HR representatives under subpoena at the hearing, and still no testimony was inserted saying, we won't do it again. Instead, what we have today is a city appealing, resisting an injunction that says you can't violate these two laws again. It is our firm belief that the injunction is imperative, not only called for under 2923.1210 as a statutory injunction, but imperative under the facts of this case to ensure that the city can't pick winners and losers and which laws to uphold and which laws not to, as far as the regulation of its employees go. I'm going to branch off into the statutory injunction argument, which I just referenced. Relying on this court's decision of the Coleraine Township v. Bench Billboard case, Timothy Kellard's injunction as a statutory injunction was explicitly permitted by 2923, and as a result, he did not have to show the potential for irreparable injury. He simply had to meet the elements under the statute to obtain his desired injunction. And that is, the city had to have violated the law, and he had to have prevailed on the challenge to that rule. The second the city amended their policies after being sued, Timothy Kellard prevailed on his challenge under 9.68, and under 2923, he was entitled to an injunction as decided to be an appropriate remedy by the Ohio General Assembly to ensure that this did not happen again. That's as far as the statutory injunction goes. I'm going to touch on the 9.68 arguments, the city's contention that Timothy Kellard did not prevail on the challenge. The plain.
Let me go to the question I asked Ms. Warner. What is your view on the Oberlin case? Should we follow that case or the lead opinion, I suppose?
I believe so, Your Honor. And I find the quote, but I'll read briefly to this court to be highly instructive to this case. And that is to require a party to obtain a court order in order to prevail on a challenge would force challenging parties to incur attorney's fees to obtain compliance with 9.68, but never prevail in a challenge such as this because it could simply repeal the offending ordinance or rule and then make off with Timothy Kellard having incurred the attorney's fees that were required to force the city to obey the law and to allow the city to obtain dismissal of this suit and avoid the attorney's fees hearing would effectively, moot 9.68 and the injunction allowed for in 2923.
But what do we do with the fact that 9.68 was subsequently amended to take into account the very point you're making?
So I do not, Your Honor, the city makes the argument that the subsequent version of 9.68 included a theory of prevailing that was not available previous to the amendment. In support, they offer no statutory canon of interpretation and no legislative history. Instead, on behalf of Kellard, I believe the plain the plain ordinary language as interpreted by the city of Oberlin states that the entire purpose of fee shifting would be, eviscerated, to be pointless if cities could just play endless cat and mouse games or other public entities.
No, I understand that point, but I guess my question is that the statute was amended to specifically account for this scenario that we are facing today.
Yes.
And so the amendment suggests, one way to read the amendment is it suggests that the statute previously did not permit recovery under that. And there are some canons of interpretation that would potentially support that. So my question is, what do we do with that amendment here?
Your Honor, I believe that the amendment was not it's supposed to expand the opportunities for a party to prevail. It was to cement the existing law on the subject, which including the city of Oberlin, to eliminate any possibility of the cat and mouse game attempting to be played by the city and city of Oberlin and other municipalities. That this was the whole purpose of the amendment, was to ensure beyond any possible doubts that once you obtain the whole purpose of your lawsuit to change the policies, that you're entitled to your attorney's fees. So I don't think that the change was a addition. I think it was concreting the existing case law and the outstanding plain language, and as has been interpreted by the trial courts up to that point. In fact, I would say.
Go ahead, I'm sorry.
Briefly, I was going to say, I think it was, my contention would be that provision was added to address the sort of the tactics pulled by the city of Columbus and city of Cincinnati and their little cat and mouse game of, oh, well, now that you've sued, we're going to dismiss and change the policies. Sorry, no fees for you.
I know your argument is that an injunction was necessary to prevent a change back in the future. But once the policy had been changed, and at that point your client had in essence prevailed under your argument, why shouldn't the court stop? Why shouldn't your client stop at that point and fees be cut off once you prevailed in getting the policy changed?
Well, Your Honor, the 2923.1210, I believe, sets forth the injunction to ensure, as part of the statutory remedy, to ensure that this cat and mouse game isn't played. So I think it's a necessary part of the change is to ensure that the city would not simply go back to its ways. And the rest of the litigation was simply all caused by the city's, failure to obey the law the first time. The city's, the litigation, it couldn't have stopped when the policy changed because Timothy Keller and the other 5,000 city employees needed some sort of concrete way to actually ensure that this was going to be settled law.
Well, but I think what Judge Myers was asking was, on the date that they changed the policy to the point you just made, the 5,000 city employees have concrete evidence that the policy has been changed. So what additional benefit did Mr. Keller obtain by continuing to litigate and continuing to incur fees from that point forward?
Well, Your Honor, I think it's like every other case where if you're going to enter into, you want a solid finding by a court as a matter of law, as a neutral third party, finding that you prevailed so you can point to something in the future. I think these employee-employer relationships can become quite contentious, and their policy changes, people move, attorneys switch firms. I mean, relying upon the city's institutional knowledge to ensure that they don't go back to violating this law. I don't think that's effective relief for Timothy Keller and the other city employees. Meanwhile,
the city ever agreed to stipulate that they had been in violation of law, or that they were enacting the current policy to bring them in compliance with law, or anything else that might give that additional protection?
In their answer, the city admits that on the day Timothy Keller filed his lawsuit, that the regulations violated Ohio law, and that any employee who violated those provisions will be punished. But as far as any testimony from any representative of the city of Cincinnati, there is none. And that is the big distinguishing factor between this case and the City of Columbus case and other lawsuits where once the defendant comes clean and puts an affidavit on the record or enters into some sort of consent decree, that gives you that judicial finding and the permanency involved. Right now, all we have is the city arguments of, well, we weren't enforcing it. And then once we obtained an injunction, ensuring that these statutes won't be violated in the future, simply ensuring they don't violate the law again, we're here. We get an appeal. It's been strident resistance in all candor to effecting a permanent change, ensuring that these laws are not violated again. And that is why
I'm sorry, Mr. Hackett, you are at your time if you want to reserve 3 minutes.
I'll reserve my 3 minutes. Thank you.
All right, thank you. Ms. Smartwarner, you have 3 minutes left.
Thank you, Your Honor. First, I'd like to address the statutory injunction argument. Mr. Kellard was not entitled to the statutory injunction because the city was no longer in violation of the statute. So as soon as we were in conformance of the statute, we were no longer establishing, maintaining, or enforcing a policy that conflicted with state law. So then you do have to go back to demonstrating the irreparable harm. And the idea that the city, after filing an answer, admitting to the court that the previous policy violated state law, would then somehow decide we're going to violate state law.
Well, then doesn't both of your injunction analyses just conflate with justiciability?
Your Honor, it's difficult because that is what the trial court did. So at the point that the city changed its policy and conformed with state law, our argument is that there was no longer a justiciable controversy and that the trial court did not have subject matter jurisdiction to enter any further orders. However, if that argument is unavailing to this court, there still was not sufficient proof to enter in this injunction because of that lack of the harm element. The harm that they are talking about is speculative. And that is not sufficient to obtain a permanent injunction. And I think that the change in the law, and specifically 9.68, really affirms this. So not only now with this new version of 9.68, it is exactly that. If a complaint is filed, we're on the hook for the attorney's fees. That argument about the prevailing but for causation no longer applies, which is even another reason why the idea we would change it in the future is speculative at best.
Wouldn't the appellant say to the appellee say to that, well, if you violated it one time and left it in place for quite a bit, knowing that it was in violation of law, what's to stop the city from doing it again? If you did it once, why wouldn't you do it again?
Because of the risk of the attorney's fees, and we now have the policies that have been amended to conform with the state law. And on top of that, we regret that the record does not make this clear, but the policy weren't being enforced at the time. Now, I would like to end on the attorney's fees argument. The trial court, if this court finds attorney fees were proper, the trial court didn't abuse its discretion on the hourly rate. The trial court was permitted to take into account what the hourly rate was for this type of litigation, and that's exactly what he did. I mean, your honors had the Buckeye Firearms case before you. You know that the 9.68 conflict was at issue there. That's all the trial court did. It was not an abuse of discretion. So
you are at your time.
I'd like to end by respectfully requesting that you reverse the trial court. Thank you.
Mr. Hackett, you have 3 minutes left, and I will remind you that that goes to the issues that you've raised in your cross appeal.
Thank you, Your Honor. I would like to quickly bring to this court's attention the recent Supreme Court case of Yuzabanam 19.968, decided on March 8th, in this 8-1 decision by the United States Supreme Court, a plaintiff's claim for nominal damages defeated a mootness argument where a policy change is made after a lawsuit. And that was found to be sufficient standing and justiciability to allow the case to continue to its final decision.
Well, did that allow for a final decision on damages or on injunctive relief?
Damages, Your Honor. In that case, for reasons unknown and for the contours of that factual record, the plaintiffs actually agreed that they did not need an injunction. So maybe in that case, they had assurances that the university wouldn't change their policies again of some kind. I didn't go back and write through the record. I'll point out that the city is sort of continuing to play this cat and mouse game with the injunction. I mean, the 9.68 changed, and so their argument is, oh, well, next time we'll get an injunction. Next time we'll pay attorney's fees. Next time it'll all be good, but this one has to go. Timothy Keller prevailed on his challenge as set forth in the plain meaning of the rule, and there's really no debate. The trial court found that he caused the policy change. That's the kind of fact-finding that trial courts are designed to do. And as a result, he should be entitled to his attorney's fees as requested. So with that, I'll go to the attorney's fees arguments. The trial court did not follow the law set forth in the Phoenix Lighting Group. Reasonable hourly rates are calculated according to the prevailing market rates. To determine the rate, there are 6 factors. And the trial court cited one, a case of apparently other lawyers who they decided they were billed at $270 an hour. And, I think if the trial court had done the full 6-part analysis and had found that we were, presumptively entitled to our requested fees, then we would be able to prevail on that issue, and the trial court should be reversed in that regard. Timothy Keller's request that his compensatory damages be affirmed, and same for his injunction, that this court enter judgment in his favor of the requested attorney's fees, and that this court remand for the attorney's fees occurred on this appeal. All the attorney's fees occurred by Mr. Keller on this matter stem from the city's violation of Ohio law for over 2 years. Nothing Mr. Keller did should design him to get his attorney's fees reduced. Are there any questions? Otherwise, I'm done.
Thank you. Counsel, thank you both very much for your arguments this morning. We will take the case under submission and give you a timely written opinion.
Thank you.
Thank you. And Ms. Kars-Nestler, if you will bring the next group into the courtroom. Good morning, counsel. The next case on our docket this morning is Crenshaw versus Michael J's Auto Sales. Mr. Hackett, I see you are still with us. You are welcome to stay, but if you do, I will ask you please to turn off your camera.
Yeah.
Thank you. Counsel, before we begin this morning, I want to let you know that Judge Robert Winkler, is also a part of our panel. He is not able to be here this morning, but he will fully participate in our deliberations and in our decision-making. He also will have available to him these arguments to review. So I wanted to let you know that before we begin this morning. Counsel, if you will introduce yourselves to the court and let us know your readiness to proceed. And let's begin, Mr. Russell, with you. I believe you are representing the appellants.
Certainly, Judge. Good morning. Adam Russell on behalf of Appellant Letitia Crenshaw. And we are ready, Your Honor.
Mr. Hoyt? And you are on mute, so you need to unmute your microphone.
I'll be dang. How did that happen? I just did. Okay. I'm sorry. Yeah, Bradley Hoyt on behalf of Appellate, I believe. I always get it mixed up. For Michael J. Auto Sales.
Thank you. Mr. Russell, of your 15 minutes, would you like to reserve any time this morning?
No, Your Honor.
All right. Whenever you're ready, you may begin.
Thank you, Judge. In appellant's brief, they seem to make some mistakes of fact. Forgive me, Your Honor. Good morning. May it please the court. Good morning, counsel.
I'm sorry, Judge Myers, I thought Mr. Hoyt was the appellant.
Oh, I may have that backwards.
Oh, Judge, I just thought the court wanted me to go first. I was surprised, but I don't question the court.
Judge Bergeron, thank you very much. And Mr. Hoyt, I was the one who confused you then. Thank you for picking that up. My notes in front of me, I had my own personal handwritten notes reversed. So Judge Bergeron, thank you very much. Mr. Hoyt, I apologize. You are the appellant. And would you like to reserve at any time this morning of your 15 minutes?
Yes. Who's going first?
You are.
You are? I am? Okay, that's fine. Yeah, I'll reserve it all and let him go first if that's satisfactory.
Well,
Does it
if
sound like he's got
you
some-
do that, he won't have anything to respond to, so that we would just take
Okay.
it submitted on the briefs, which we are.
Oh, okay, well, let me go. I can go ahead. If that's
Right.
okay.
How much time would you like to reserve in response to Mr. Russell?
I'll reserve 5 minutes, please.
All right, then you will have 10 minutes whenever you're ready.
Okay, thank you. Yes, Your Honor. I just wanted to start off with a little history so the court's aware of what type of transaction this was. Michael J. Auto Sales buys cars at auction as is. Many of these cars are trade-ins from the big dealers. They get cars over 100,000 miles. They don't want to deal with them, and they wholesale them out as is at an auction. And Michael J. buys these autos that way. He prepares them for sales, fixes them up, and sells them wholesale as is. Usually he sells them for $2,000 to $5,000, something like that. He sells 100 cars during tax season, which is the first 6 months of the year. He sells about 100 of these cars a month. This car, for instance, I just looked up the book on it. It was about $5,750 retail. He sold this car to the lady, I believe, for $3,195. So it gives you a sense of what his business is like. This car was a 2005 Nissan. It had 171,000 miles on it at the time. And at the time of the sale, it was all sold as is. Everything was done. The only thing that's, I think, in dispute here is a we owe document. It was my exhibit and their exhibit also. And we had a magistrate in small claims court render a judgment for $1,614, of which I objected to. This we owe, I contend, is a separate contract. The lady bought the car on July the 28th. She took delivery on it August the 1st. She brought it back, or had it towed back August the 2nd.
Well, Mr. Hoyt, on the WEO agreement, I mean, the magistrate reviewed the factual record and concluded that your client had not fulfilled that agreement and made specific findings. In fact, found that the brake pads were done, so she deducted that from the conclusion. So what's the matter with those factual findings that were made by the magistrate?
Well, the problem is she took delivery of the car, and she took delivery August the 1st, And if it was one of her big contentions was exhaust, loud exhaust. Well, if that's true, I mean, you take delivery of an exhaust, it's pretty evident if it's loud or not loud.
But there's a separate WEO agreement that said this is the stuff that you are going to perform. So even if she takes delivery, if you've signed an agreement that says we're going to fix this stuff,
right? And she did. They did. And
that's not what that's not what the magistrate found, though.
Well, that's part of the error. It's part of the error.
Well, but that's my question. Why is that error? Why did the magistrate's findings? Why are they wrong?
Well, because she took delivery August the 2nd. Delivery under the magistrate's decision was that these things were not performed, but the lady took delivery August the 2nd, brought it back, took delivery a second time. And in my understanding, under ORC 1302.64, that's acceptance. She accepted this car as delivered and performed. So to me, that and it's a separate contract itself. This WEO is a separate contract, and noted on our exhibit was checked off that everything was performed. A month later, on September the 17th, she takes it in for a estimate, and in that estimate, there were a lot of things that weren't even on the WEO deal. The WEO, if you examine the WEO document, it says brake pads. Well, they ended up repairing, putting new rotors on it. They ended up putting a catalytic converter on it. They ended up fixing a seat. They ended up doing an airbag. And there was only like in that whole bill, there was only $153 for these brake pads out of $1,754. So all those repairs were not even on the WEO. The majority of the repairs. The loud exhaust, there was we objected to the magistrate's decision. The magistrate's decision was only $1,614. We objected to it, but the judge found that and we asked for a hearing on the objection. We were not granted a hearing. The judge's decisions comes back that we had violated Consumer Protection Act. Well, no place in the hearing or in their complaint even, and their complaint was for $5,500. But no place in their complaint even was anything about the Consumer Protection Act. But then the judge found that there was fraud, and I'm torn to find any fraud because duty to disclose. I mean, the WEO was a disclosure. It was repaired. She took delivery. I don't know where there's an intention to mislead that he found it was fraudulent. So that was another thing. But I think this is also a first impression to the court of a small claims going over a $6,000 judgment. And I think his judgment's for $8,000 and some dollars. And that judgment even exceeds the complaint for $5,500. And
so what's the best authority to show that is inappropriate?
The statute called small claims jurisdiction of $6,000. And I think I briefed that on my brief. Yes, I did. As far as unconscionable sales practice, the car that she admitted the car was repaired 2 times. The judge even added things to the complaint that weren't even in the complaint. And that's kind of my position, and I think that's pretty much my time for.
All right, thank you. You will have 6 minutes left. Mr. Russell, you may proceed whenever you're ready.
Thank you, Judge Myers. And I did misspeak. I represent the appellee, Ms. Crenshaw. Thank you. Good morning. May it please the court. Your honors, I believe appellant remains confused about some factual findings. They continue to argue that this was an as-is transaction. However, the magistrate determined correctly that this was not an ordinary as-is transaction where you just take the car and drive off the lot and it's done. They actually made some express promises contemporaneous with the as-is sale. Those express promises are not disputed. There was no objection that a contract was actually formed. There was no objection that there was a meeting of the minds that these things were actually owed. Appellant's objections seem to just be that they think that they fixed these things, and the court found that they did not. The argument that she accepted the goods is specious. The testimony was that she purchased the vehicle on July 28th, paid $1,300 down cash, and had a list of items that she was promised would be repaired. The only implied warranty at issue is the implied warranty of good faith and fair dealing that we have when we go as a consumer anywhere to purchase a good. We assume that the person is going to do what they promise, and we don't have to second guess that. Well, when she went back to pick up the car on August 1st, they handed her the keys and they said the repairs are done. Her testimony was that she was told the repairs were completed. That's the fraud. That is where the deceptive practices come in. She was told that work was done, that the finder of fact determined was not actually done. And the finder of fact is, of course, in the best position to determine these things. The magistrate heard from Charlie Beaver, who was a disinterested witness that Ms. Crenshaw subpoenaed. He actually examined the vehicle, testified that none of the repairs had been done. He testified that it was not drivable, and that if she drove it for an extended period of time on the road, she'd actually be stopped by law enforcement because the exhaust was so loud.
Did your client, go ahead, Judge Bergeron.
No, go ahead, Judge Myers.
Did your client raise the Consumer Fraud Practices Act, Consumer Sales Practices Act in its complaint?
She didn't use those magic words. As the magistrate pointed out, she was pro se. And in small claims court, I think that as lawyers and in jurisprudence, we want to give access to people to be able to bring claims. And in that regard, they're given a little more latitude with these types of complaints. She did put the defendant on notice of $5,500 in damages. And as the court pointed out, this is not Michael J's first rodeo with this type of thing. They're on notice for these types of claims. And as a counsel for appellant pointed out, they sell all kinds of these vehicles all the time. That being said, we do want to enter a brief objection to any facts that were argued that were not part of the record and move to strike those. I don't think a lot of the things argued by appellant at the beginning were on the record, but certainly.
But let's go to on the Consumer Sales Practices Act. I mean, from a due process perspective, I understand your argument. She's pro se. We don't want to hold them to the rigors of that, but we're on objections to the trial judge. And how is Michael J, when they've requested a hearing and not been granted a hearing, but how are they ever supposed to know that they're subject to potential damage under the Ohio Consumer Sales Practices Act?
Well, in her complaint, she, again, Your Honor, thank you. She pled for $5,500. She asked for various things that we as lawyers know are not necessarily allowed, like pain and suffering over a contract. She asked for other items, etc. She asked for damages that were arguably treble damages when compared to the economic damages that she requested. She requested, I believe, fees, times for off work, the kind of things that are in the breadth of this Consumer Act statute that awards these treble damages and different kind of costs. When a consumer has to go up against a corporation, the court favors deterrent of that future behavior. So our argument is that she did the best she can to argue the type of damages that she believes she was entitled to for these egregious practices. So egregious that she contacted the Better Business Bureau. She even had to have a police escort come to get the vehicle. And so any argument that she failed to reject the sale and accepted the goods must fail. Any reasonable person sees that she was up in arms doing the self-help, everything she can against this business. And really, she just put anything she could on that complaint for any relief that she may be entitled. CR 53 allows the court to come in and modify the decision. And Michael Jace, they could have accepted that judgment. They asked for it to be reviewed. And I think that the courts.
Well, let's go to the question about exceeding the jurisdictional threshold of small claims court. I mean, what would the authority be to say that the court was entitled to award more than that jurisdictional amount?
Thank you, Your Honor. Yes, there is an exception. I believe it's in RC 1925 A2 A and B, which that's what limits, I believe, the authority of the small claims court to the 6,000, but it creates an objection for anything found under subsection B of Revised Code 134509. Section B of Revised Code 134509 is, of course, it says where the violation was an act or practice declared to be deceptive or unconscionable. And again, this is allowing a specific exception for judgments in excess. The idea, I believe, is we don't want to require a small claims litigant to have to go all in up in an upper court and go through discovery because they're asking for treble damages. That first threshold, that evidentiary threshold, has to be met before that would kick in. And the legislature appears to have created I don't want to say a loophole, but an exception for these types of situations. Again, the access is
what you're saying, if I understand it, is she could request a single damage amount that is within the jurisdictional threshold, but then the court, if it found a violation of the Consumer Sales Practices Act, could treble that, even if that trips over the amount.
Correct, Your Honor. That's our position. Whereas if she would have prayed originally for $7,500 in damages and then to treble those, that would exceed the jurisdiction of the court, and the magistrate never had authority to hear it in the first place. And then I just finally want to say that as a pro se litigant, I think that she did a fine job. She subpoenaed her own witness. The evidence of appellant at trial was underwhelming at best. There was only some evidence that the one self-serving witness who had been alleged to have, cursed at Miss Crenshaw and hung up on her, Miss Bragg, she testified that she got some hex bolts out of one vehicle and put it in the dashboard of the other, which is a common thing that we see in these types of car transactions, a common complaint. Just get the car aesthetically good enough to drive off the lot. And then Miss Crenshaw testified she didn't even make it home on that first day. She called him immediately, had to get a friend to help her get the car home, towed it back. That's not an exception of goods. She waited. They again told her the car was ready. Took it, not repaired again, called them, brought it back, arguing, police have to come. That's not an acceptance of goods. That argument must fail. And then to her credit, she also made every single payment under the contract. The testimony was that she paid off the entire vehicle. And this was a second car that Ms. Crenshaw had purchased to help her get her daughter back and forth to cheerleading. It was clear that she needed to have a safe vehicle. That's not what was delivered. And the trial court's in the best decision to evaluate the credibility of these witnesses. They did not find appellant's witnesses to be credible. They found Ms. Crenshaw's witnesses to be credible, and that underlying decision, I think, should not be overruled.
All right, Mr. Russell, you do have some more time if you'd like to use it, and if not, we will go back to Mr. Hoyt.
I think that I've made all the arguments I'd like to make in a succinct fashion. If the court does not have any other questions, then we would rest our time.
All right, thank you. Mr. Hoyt, you have 6 minutes left whenever you're ready.
Thank you, ma'am. I apologize for not putting my coat on. I feel so comfortable here. But I have all full respect for the court. Back to the complaint. I have the complaint in front of me, and the complaint I was defending against was failing to complete car repairs listed on sell order, towing fees, broken front passenger seat, check engine light, and etc., along with other things, pain and suffering, loss of pay from work, court fees and summons fees for witness. And then she had written in there, wrong price on title, not something lien of title. But anyway, there was nothing about Consumer Protection Act or any of the things found by the judge to be in violation of Consumer Protection.
Well, if she says wrong information on title, isn't that at least arguably something fraudulent that would fall under the statute?
Well, she said wrong price on title, and that was never determined to be a problem. In fact, I think it was worked out with the magistrate that the title was correct. But that's not, from what I read from the judge, not the magistrate, from what I read from the judge, that was not an issue, the wrong price on title. As far as I could still contend this was an as-is sale, and this was a separate contract, the we owe. And I note on the we owe, that was a 30-day contract. We owe the understanding this is valid for only 30 days from the date. And it was September the 12th, I believe, that she had this estimate done, which there was never proof to the court that she actually had these repairs done, but she presented an estimate. And again, that estimate was for 90% of the work was not a part of the we owe at all. So, and again, Beaver, he was a witness. She had called in. He said, and again, it was a month and a half later, said the car wasn't drivable, yet he didn't drive it, or he didn't even attempt to drive it. He said it appeared the brake work was not done. The car was really loud at that time, and that's part of the problem. A really loud car is noticeable, and you make objection right then. You don't take it out, drive it, I don't know how far, because there's never any proof of mileage put on this car, but it was admitted that it was driven considerably for a month and a half before any action was brought. That's all I've got, Your Honor. I really didn't get a chance to defend this case under the Consumer Protection Act. Thank you.
Thank you both for your arguments this morning. We will take the case under submission and give you a timely written opinion. Ms. Kars-Nessler, if you will let the next group into the courtroom.
Thank you, Your Honors. May I be excused, please?
Yes, and Mr. Hoyt, same for you.
Thank you.
Good morning. We are back on the record for our oral arguments this morning. The next and last case to be argued today is Banker's Choice versus the Zoning Board of Appeals. Counsel, before we begin, I want to let you know that Judge Robert Winkler is also a member of our panel. He is unable to be here this morning, but I wanted to let you know that he will fully participate in this case, in our discussions and in the decision, and he will have available to him the arguments this morning. So, counsel, if you are both ready to begin, and let me just start with counsel introducing themselves. Mr. Haynes, on behalf of the appellants, if you will introduce yourself, and then we'll turn to Mr. Barrett.
Good morning, Your Honor. Marion Haynes on behalf of the Zoning Board of Appeals for the City of Cincinnati and City of Cincinnati. Also watching via YouTube is co-counsel Kevin Tidd, who was not able to join for the argument. Ready?
Mr. Barrett? Thank you.
Yes, this is C. Francis Barrett. Right next to me is Joshua Good. We're on behalf of Banker's Choice and Style Development Corporation appellees.
Good morning, Your Honor.
Morning. Thank you both. Mr. Haynes, of your 15 minutes, would you like to reserve any time this morning?
Yes, Your Honor. I would like to reserve 2 minutes, please.
All right, and whenever you're ready, you may begin.
All right. Thank you. Good morning, and may it please the court. Marion Haynes for the City of Cincinnati Zoning Board of Appeals. This is the third appeal concerning the appellee's request to demolish the Davis Furniture Building, which is a protected historic building in the Over the Rhine neighborhood. For the third time, the trial court's decision should be reversed. While the trial court addressed the correct 3 legal factors this time, the city contends that the trial court's decision that its legal conclusions are not supported by a preponderance of the evidence as a matter of law. Throughout these proceedings, the trial court has viewed this case entirely through the wrong lens. It has looked at it as a property management case or property maintenance case and deferred to the extent that the property owners want to invest in it. But the standard in this case is whether they have proved economic hardship. And for that legal standard to be met, the trial court's finding.
The trial court walked through the 3 criteria that we said it had to consider. And it made findings, obviously, that you're challenging here today, but ultimately it did make the necessary findings. So I guess I'm trying to understand how do you get around that?
Yes, Your Honor. So the trial court made factual findings and it made legal conclusions. What the city is saying is that those factual findings as a matter of law do not add up to those legal conclusions. The court can't declare facts and declare the facts to equal the law if they do not actually equal the law. I think a good analog here might be thinking about this in the way, though it's not exact, the way that the court might review a case that's been dismissed for failure to state a claim. You look at the facts that have been alleged in the complaint. Here, the city's not asking the court to reconsider or reweigh facts. It's saying, look at the facts that the court found. And in that case of failure to state a claim, you would say, do these facts actually state a legal claim?
Okay, so why don't you give me a specific example? Like, what are the facts found by the court that are inadequate as a matter of law to meet the requisite criteria?
Sure, Your Honor. So let's take all economically viable use, the first of the 3 criteria. When you look at the court's factual findings, the court finds that it would be essentially difficult and expensive in order to renovate the building. Well, difficult and expensive does not equate to denying all economically viable use, because you can do things that are difficult and expensive, but still have a payoff at the end. It's difficult and expensive to pull gold, to mine gold out of the ground, but it can also come with a payoff.
But if you tried to do that here in Cincinnati, you would be on a fool's errand. So, I mean, I guess you're right that sometimes you can get a payoff from difficult and expensive work, but sometimes you can't.
That's true, Your Honor. And but the point is, you need something more than just saying that this is a difficult and expensive task to know what the payoff is going to do. It may be difficult and expensive to mine gold in the city of Cincinnati. That's true. It is not quite so difficult. It is not quite so economically impossible to metaphorically speaking, dig for gold in renovating old historic buildings in the city of Cincinnati. And in fact, quite a few carry on in that trade within the city. So again, just concluding that it's a difficult and expensive task to do does not automatically reach the conclusion that the trial.
Maybe let me approach it this way. So what would the finding have had to have been to satisfy this one? Would the court have needed to find that there is no possible way to renovate this without basically spending more than it's worth? I mean, I guess I'm trying to understand, where do you draw the line?
Yes, I think at its most simplest level, Your Honor, that's exactly what should have happened here. It said, is the investment that's going into this property going to exceed what is going to come out? And what we have here is, we know that it's going to be hard and it's going to take a lot of money to renovate this building. What we do not know is what that building would be worth, what the return on that investment would be if that investment were made. And the trial court never required that rigor in the standard, never made any findings, and that's because there's no real evidence on it in the record beyond the property owner saying that they don't think there would be a payoff for them. There's no.
Well, and did the city offer any evidence of what the ROI would be?
The city did not offer evidence, Your Honor, but I think that looks at the city's role in this case in the wrong way. I'm representing the Zoning Board of Appeals of the city, which is in some ways a tribunal that reviews the evidence that's been presented by the appellees and others within this case and tests the sufficiency of that evidence, just like the trial court did. So the city does not have the burden at any point throughout these proceedings to provide evidence or to rebut evidence that's been presented by others. So it was not the city's obligation to prove the negative. It was throughout these proceedings the appellee's responsibility and burden to make those showings. And they've not done that beyond just their own bringing members of their own corporation and testifying in very generic and conclusory ways that there's no economic way to renovate this building.
Would you agree that there's at least some confusion in the case law and maybe even case law in the first district about what economic viable use is or what the standard is for that?
I would say, Your Honor, that standard pops up in a number of different contexts. And depending upon the context and depending upon the type of claim appearing before court, we tend to get different views. But I think, generally speaking, the all economically viable use prong of this, again, tests whether it's economically possible to make investment, in this case, in this building, and achieve a measurable return. Here, we have all the cost side of the ledger. We don't have the second half of the equation. A plus unknown X factor equals C, and the court didn't ever determine what B is to determine if A plus B equals C, if that makes sense. I think also when you get into the two other factors, when you look at the reasonable investment-backed expectations, again, kind of like with all economically viable use, we don't know how the trial court reviewed that factor. The trial court never explained it or looked at the case law. But what we do know from the case law is, one, this court has said that there has to be objective evidence of what are actual reasonable expectations. And we do not have any evidence of what objective investors would have hoped to achieve from this property. Sure, everyone, including the property owners, as the trial court said, would hope to restore the building if it's, quote, economically appropriate, but that doesn't tell us anything within this analysis. We need to know, what would somebody who purchased a building at a sheriff's sale, who's an experienced developer, who knows that it's subject to historic preservation rules, what would that person expect? And not what the particular property owners expect in this case, but what would a normal developer expect?
But I guess I'm confused on that analysis. Are you saying like the court should have retained its own expert to figure that out?
No, Your Honor. This is a record hearing. And so the court can only look at the record. And so what the trial court should have done is the trial court should have said, there is not enough evidence in this record on which I can reach this legal conclusion. That's what the ZBA before it did, but the trial court essentially ignored the absence of evidence and essentially gave the appellees all the presumptions simply because they testified that it would not meet their particular expectations. So again, this court has said, you have to look, trial court, are there objective investment-backed expectations here? And the trial court never tells us what they are, never shows where that is in the record, and that's because it absolutely doesn't exist. And if it doesn't exist, the trial court should have said, I cannot conclude to this factor. There is not evidence here. And so the appellees have not met their burden. And then similarly, on the same prong, both this court and the trial court recognized that there were multiple offers to purchase this property. And we know why the appellees turned it away. They say, hey, we really bought this property to, quote, alleviate the eyesore across the street. Everyone recognizes that. That's clear within the record and within the cases. And then they say they turned these offers down that would have brought them quite a substantial return, because these offers didn't agree to renovate the building on the schedule that they wanted. Again, that may be what they want. It may be a legitimate reason why they don't want to sell the property, but this is an economic test. This is a test whether a reasonable, objective developer who has someone make an offer for 2 or 3 times what they paid for the property would walk away from that offer. Here, there's other reasons, subjective reasons that do not align with objective realities. Again, we don't have enough evidence in the record, and that's part of the difficulty I have here. Is I'm in the position of having to prove the negative in a case when I don't have the burden to prove the negative, because we have an utter absence of evidence that the trial court looked past. And then on the third factor, whether the property owners exacerbated their economic hardship or created it, again, the trial court treats this like a property maintenance case. All the trial court really discusses is whether the property owners did things that caused the building to deteriorate. And it says they purchased this property in a deteriorated position or condition. But again, the trial court looks past and just kind of arbitrarily ignores all the objective factors here that weigh heavily against any finding, or that I shouldn't even say weigh, I should say that prevent a finding that they didn't contribute to their own economic hardship. First of all, was buying the building and the reasons why they bought the building.
But how does just buying the building contribute to the hardship?
Your Honor, when you are an experienced over-the-Rhine developer who knows it's difficult and expensive and a risky proposition to buy a building that you've watched deteriorate for 10 years and is subject to historic preservation rules that do not allow you to tear the building down without proving economic hardship, you know right off the bat that you are making a very, very risky investment. So you create the hardship and then turn around and complain of and say, I didn't know it was going to be.
I mean, I don't know that that's creating the hardship. You're buying the building. It's not like you did something to the building that made it worse. I mean, that's kind of how and maybe I'm totally wrong, but that's how I would read just the plain language of that prong, is that you've done something that has made the situation worse. I don't see how someone buying this at a sheriff's sale, just that act can satisfy that.
Well, again, I understand the court's point on that. I definitely think if you put yourself in a position, it is not then something that you can turn around and complain of. If it wasn't like they purchased it naively, were not aware of the conditions, that it was something that they had investigated, and then suddenly find out all of a sudden, whoa, this isn't going to be as easy as we thought it was. So the hardship is the hardship that they are complaining of, and they did create it by purchasing it. I'll also
Mr. Haynes, you are at your time if you want to reserve 2 minutes.
All right. I'll just finish quickly, Your Honor, that on the second point, I think they contributed to it by turning down purchase offers that have been recognized to be legitimate and credible. And we believe that, based upon the few facts that are available, the trial court's decision should be made. Thank you.
All right, thank you. Mr. Barrett, you have 15 minutes.
Thank you. This is Fran Barrett with Josh Good on behalf of the appellees. The test is whether or not the owner suffers economic hardship. And there are 3 factors which this court directed the trial court to apply. Those are to be considered. They're not binding, not mandatory. They have to be considered. And the trial court not only considered all 3 factors, but found in favor of the property owners on all 3 factors and found evidence in support of all 3 factors. With respect to the first factor, will all economically viable use of the property be deprived without approval of a certificate of appropriateness for demolition? The trial court stated in its decision on page 3, quote, "This court is compelled to answer yes," unquote.
Let me ask you a question, Mr. Barrett, about that. Why isn't Mr. Haynes right that you have to consider both the revenue side and the expense side, the value equation, to determine that factor? And the court looked only at how expensive it would be and didn't evaluate what the return on the investment would be at the end of the day.
Mr. Michael Stow and Mr. Scott Stow both testified they considered all scenarios for redevelopment of this property. They considered the income, and Mr. Michael Stow specifically testified under oath and subject to cross-examination that there's no net income that can be derived from rehabilitating this building, restoring this building under any scenario. He testified as to the income that could be derived, and the expenses exceed those. So there's no net income that can be derived. So that test is fully met, Your Honor. I note that also the trial court stated on page 4 of its decision, quote, "Further, this court found and specifically stated in prior decisions that Banker's Choice presented credible evidence from experts in the field of property restoration and the financial aspect of property restoration that the Davis Furniture Building would be economically not viable," end quote. That's the finding of the trial court. There's more than substantial evidence in the record in support of that finding. The trial court went on to say, quote, "Banker's Choice presented credible evidence that the only economically viable situation for them was to seek a certificate of appropriateness. The sale of the property was not deemed by Banker's Choice to be economically sound." Again, with regard to those offers, as the point was made by Mr. Michael Stow and Mr. Scott Stow, the proposed offerors never would commit to restoration, would never commit to contractual terms that didn't include things they could not agree to. There were requests for representations and warranties concerning the condition of the building that were not only inaccurate, but they could not validly make. The court went on to say, quote, "The credible evidence presented to the court shows that Banker's Choice could not make the Davis Furniture Building economically viable without the certificate of appropriateness. The building is crumbling. It is dangerous. They have provided the court with a sound legal and factual basis to show that they would be deprived of all economically viable use of the property without the approval of a certificate of appropriateness," period, end quote. That's the finding of the trial court, and finding is supported by evidence in the record, and finding cannot be set aside by arguing weight of the evidence as the city does in its brief on appeal. With respect to the second test, will reasonable investment-backed expectations of the property be maintained without the approval of a certificate of appropriateness? The trial court said, quote, "The answer must be no," period, end quote. The trial court goes on to say, "The record reflects that Banker's Choice indicated an intent to restore the building if economically appropriate." That's exactly right. Banker's Choice bought the property with the intent to restore it if it could be done feasibly. If not, the only alternative is demolition. The goal was to eliminate the blight. The blight was, in the first instance, was to be remedied by restoring it if it could be. And the evidence in the record is Mr. Stow went in the building for the first time after he bought it at sheriff's sale with his architect and his structural engineer. They inspected the building. After a full inspection by both the architect and the structural engineer, concluded it was not economically viable to save the building. The judge was on to say, he quotes the Court of Appeals, your court in its prior decision in 2018, quote, "They, the Stows, know what they're doing. Their expertise was appropriately presented to the trial court, and the record of these proceedings so reflects. The property owner's expectations are based on reasonable and objective standards." At the top of page 6, the trial court says, quote, "Again, Banker's Choice," the record reflects, "bought the building with restoration and financial investment, among other things, in mind. Unfortunately, the reasonable investment-backed expectations could not be made to come to fruition," period, end quote. With regard to the third test, about whether the economic hardship was created or exacerbated by the property owners, the trial court says, quote, "The answer is clearly no," period, end quote. The court goes on to say, quote, "It was deteriorating, unsafe, etc. before Banker's Choice bought it. Banker's Choice did not create an economic hardship related to the building. The record, according to the interpretation of this court, is devoid of evidence, credible at least, that shows Banker's Choice did anything to exacerbate the economic hardship," period, end quote. Simply stated, those are the findings of the trial court. Not only did the trial court consider all three factors, it found all three factors and evidence in support of the position of the owner that each factor is decided and resolved in favor of the property owners. I also point out that the evidence in the record is uncontroverted by Mr. David Caudry, who's the commercial realtor. He marketed this property heavily. When he first marketed it, there was interest in the property because it's over the Rhine. But whenever, as he testified, whenever anybody came in to inspect the property after they saw the condition of the interior of the building, they immediately had no interest. He tried to get 3CDC to inspect the building, they would not. He tried to get Granite Properties to inspect the building, they would not. He also pointed out that after the Zoning Board of Appeals hearing, there was no interest whatsoever in the property from anybody. He explained that Tender Mercies could not consummate its contract because it couldn't get financing. As Mr. Scottsdale testified, the reason they couldn't accept the terms and conditions of the offers of 3CDC and Granite Properties was because there were representations and warranties that were made concerning the condition of the building, which were simply inaccurate, could not be made. Certainly, someone buying the building might want those representations and warranties, but legally, you can't make someone accept warranties and representations which are factually contrary to the conditions of the building. So, as Mr. Scottsdale testified and Mr. Michael Stout testified, they looked at the possibility of restoring the building for a variety of uses, and under no conditions could those uses be economically viable. There'd be no net income. The estimate of restoration rehabilitation by Mr. Michael Stout was questioned at the Zoning Board of Appeals. He had estimated something in the range of over $2 million, and it didn't work at that, and it did not work at that level of cost. The urban conservator, Mr. Larry Harris, maintained that those costs were inflated; they were too high. At the hearing on the injunction, the city sought an order requiring the building to be restored. Mr. Michael Breitz, who is the president of Structural Systems Repair Group that does most of the restoration work in Over the Rhine, he's also a principal in HDC Construction, which is the prime contractor in Over the Rhine. His estimate was over $3.3 million, over $1 million more, confirming that it is simply economically infeasible. The basis of the position of the city was that Larry Harris had testified in front of the Zoning Board of Appeals that it was economically feasible to restore the building. In court at trial, when he was first subject to cross-examination, he testified, he admitted under oath that it was not economically feasible. He had no evidence in support of economic feasibility. He simply supposed it was. He had no evidence to support that, and the only evidence of economic feasibility came from the Stouts, who proved it was not economically feasible. That's part of the trial court record. So,
Mr. Barrett, when you make that statement, were there, as a part of the record, were there any projections or any financial statements that would have shown the economic infeasibility, or was it simply the testimony?
no, there were pro formas that were prepared. Mr. Michael Stout testified to. Actually, he testified to those at the Zoning Board of Appeals. They're in the record. Mr. Michael Paul, who's the architect, testified that under no scenario could it be economically feasible with the numbers work out. That is in the record, Your Honor. Basically, again, the test is whether there's economic hardship. There's more than economic hardship here. It must be emphasized, and this court recognized it before, that Mr. Michael Stout Sr. has over 50 years of experience of restoration work, historic preservation in Over the Rhine. He was the former president of the Chamber of Commerce, the Over the Rhine Chamber of Commerce. He's the one who rehabilitated Main Street, made it what it is. This building was neglected and ignored for over 10 years. He tried to get the city for 10 years to correct it, and they wouldn't. He finally went to the sheriff's sale and bought it. He bought it as the express with the intention of seeing if it could be restored. His architect went through the building. His structural engineer went through the building. They determined economically it could not be done feasibly. Even at the hearing on the city's injunction, the city sought orders requiring them to bring the building fully up to code. Trial court denied that injunction, and this court affirmed the trial court's denial. But the structural engineers who testified at that point in time, Mr. Richard Meyer and Mr. Michael Frank, both testified that it could not be, the cost of restoration were prohibitively expensive. It would be a waste of money to spend the money trying to rehabilitate this building because of its structural deterioration. So, Your Honor, is basically the evidence, I believe, is overwhelming in support of all three criteria. If you have any specific questions, I'm happy to try to answer them.
Bergeron, any additional questions?
Thank you.
No. Thank you, Mr. Barrett.
Thank you, Your Honors.
Mr. Haynes, you have 2 minutes. And if you will start, if you don't mind, by addressing Mr. Barrett's point that there was evidence in the record that it was not economically feasible, including testimony from the architect and an opinion from the engineer.
Yes, Your Honor. So quickly, Mr. Barrett, you'll hear he offered up the numbers, $2 to $3 million to renovate the building. What you have not heard is any quantitative figure for what the building would actually be worth. All that we have is the generic testimony of Mike and Scott Stow, the owners of the building, just concluding that they looked into it and it's not economic. So we don't have anything to balance those numbers against. The person who presented the pro formas, the quote unquote architect, also an executive of the Stow Group. This is all coming from inside their organization, and they just conclusory determined that it wasn't economic.
Well, isn't that a credibility determination, the fact that they're inside, whether they might have a bias? I mean, if there's testimony in the record to support it, it's not up to us to determine the credibility of the witnesses, is it?
It's not for this court, but Your Honor, it has to be objective. It cannot be subjective. And if all of they're saying is, sure, I think this is a bridge too far for us to take on, that's not objective evidence. And I don't think this court can find that that's objective evidence.
But if they have expertise in this area, I mean, yes, they have a bias because they have, want to get this approved. But I mean, do you have to show evidence to the contrary that would show that they're wrong and that there is something that can be done with this?
I think that they have to provide actual credible evidence, Your Honor. And for the trial court, and if this court affirms it, that all you have to prove is that it would be difficult and expensive, and the property owners just conclusory say we think that's too expensive because we're developers who do buildings, then you've essentially eviscerated the standard. There's no rigor in the standard anymore. And this is supposed to be a very weighty standard, because once these buildings are gone, they're gone. And so what the court really has to say is there has to be a real test here. It has to be a sincere test, and it can't simply be we're going to take them at their word. There has to be some support that their word is objective and reasonable, and there isn't other than their word. And if that's all that trial court has to do is say, I think this is a good person, he's really smart, so I'm going to take his opinion without testing it in any way or without relying upon any quantitative evidence, no appraisals, no market study, no actual even plans against which they're tested, the way that which every developer in this entire world develops property. There's nothing like that in this record. And there's nothing that Mr. Baird has pointed to other than, again, their own conclusory, their pro formas relied on 100% financing. Who finances even their house without putting down a down payment, without at least government assistance? It just doesn't happen. And it doesn't happen in commercial real estate. And so what we have here is essentially the property owners taking all the evidence that they have that shows it's hard, but none of the evidence that shows what it's worth. And without that, I just don't see how a court can conclude that there's a denial of all economically viable use. And that's before you get into even talking about what objective returns are or whether there's been exacerbation of their hardship, including by turning down offers from credible developers. What does the Stow Group care if those people came through for inspections if they're offering 2 to 3 times the value of the property? It's a red herring. This whole thing is all these diversions away from the fact that you had credible developers who were going to pay substantial amounts for the property, and they turned them down. Why?
Mr. Haynes, you are at your time. If you'll wrap up, please.
Thank you, Your Honor. As I say, we do not believe that the trial court's legal conclusions are supported by its factual findings, and that this court should reverse the trial court's decision. Thank you.
Thank you. Thank you both very much for your arguments this morning. We will take the case under submission and render a timely written opinion. I will conclude arguments today for the First District Court of Appeals. Thank you all very much.
Thank you.